Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 4th April to 9th April 2022. In first important news, the Supreme Court has held that non-disclosure of material information can be a ground for termination of services. In the case of Union of India versus Dilip Kumar Malik, the Supreme Court has held that non-disclosure of material information could be a ground for termination of service. The court has said that it remains beyond the pale of doubt that the cases of non-disclosure of material information and of submitting false information have been treated as being of equal gravity by the court, and it is laid down in no uncertain terms that non-disclosure by itself may be a ground for an employer to cancel the candidature or to terminate the services. In second important news, the Supreme Court has upheld the validity of the Foreign Contribution Regulation Amendment Act. In the case of Noel Harper versus Union of India, the challenge was made to the 2020 amendments made to the Foreign Contribution Regulation Act of 2010, which has been upheld by the court. Now, this amendment introduced restrictions in the handling of foreign contributions by organizations in India. The court has held that it is open to a sovereign democratic nation to completely prohibit acceptance of foreign donation on the ground that it undermines the constitutional morality of the nation, as it is indicative of the nation being incapable of looking after its own affairs and needs of its citizens. The court has stated that there is no absolute right to receive foreign contribution. In third important news, the Supreme Court has held that ad hoc payment made under interim orders does not form part of wages under the Payment of Wages Act. In the case of Chairman cum Managing Director FCI versus Rajesh Chandra Srivastava, the Supreme Court has held that an ad hoc payment made pursuant to the interim orders passed by the court does not form part of wages within the meaning of the expression under Section 2 Clause S of the Payment of Gratuity Act 1972 for the purposes of calculating gratuity. In fourth important news, the Supreme Court has held that arbitral award cannot be set aside on the mere ground of erroneous application of law. In the case of Haryana Urban Development Authority versus Mrs. Mehta Construction Company, the court has held that an arbitral award can be set aside as per the terms given in Section 34, Clause 2b of the Arbitration and Conciliation Act 2013, or when it is vitiated by patent illegality and not on ground of erroneous application of law or by misappreciation of evidence. Lastly, the Supreme Court has held that an income tax notice is not invalid merely because it was sent to the amalgamating company. Amalgamation doesn't wind up the company. In the case of Principal Commissioner of Income Tax versus Mrs. Mahagun Realtors Limited, the court has held that amalgamation is different from winding up. Upon amalgamation, cause of action does not cease per se. In this case, the court has held that whether a corporate death of amalgamating entity upon amalgamation per se invalidates an assessment order issued under the Income Tax Act or not cannot be determined on a bare application of Section 481 of the Companies Act 1956 or its equivalent in the 2013 Act, which deals with the dissolution of the said company. The court has said that the same would depend on the terms of the amalgamation and the facts of each case. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.